Welcome to Community Legal Education Association's Legal Information for Tenants in Manitoba video series. This video is about above guideline rent increases. This video was produced by Community Legal Education Association Manitoba, or CLEA, with funding provided by Justice Canada. CLEA is located in Winnipeg, Manitoba on Treaty 1 territory, the traditional gathering place of the Anishinaabe, Cree, Oji-Cree, Dakota, and Dene peoples, and the traditional homeland of the Métis people. Our water is sourced from Shoal Lake 40 First Nation. We acknowledge that much harm was done in the past and continues to be done. Therefore, we dedicate ourselves to moving forward in the spirit of reconciliation. This video contains information about Manitoba laws and is only intended for Manitoba residents. This video contains general legal information only and not specific legal advice. For legal advice about your specific situation, speak to a lawyer. No one likes to hear that their rent is going up. When your landlord tells you about an increase or proposed increase, there are some things you can do to try to reduce or prevent an unfair or unreasonable increase. For any rent increase, your landlord has to tell you in writing at least 3 months before it can take effect. Usually, rent can only be increased once a year. If you are receiving a rent discount, your landlord must also provide 3 months' notice before removing the discount. However, if you receive a rent discount that is conditional, meaning it depends on something you do or don't do, the landlord does not need to give notice if they are reducing or removing the discount because you didn't meet that condition. For example, a tenant could receive a rent discount that applies only if they pay their rent on time. If the rent is not paid on time, the landlord can take away the rent discount without notice. Most renters in Manitoba are protected by a limit on how much their landlord can increase the rent each year. These limits are set by the government at the start of each year, taking into account the cost of other goods and inflation control. The 2026 rent increase guideline is 1.8%, effective January 1st, 2026. That means if your rent in 2025 was $1,000 per month, your landlord could legally raise your rent for 2026 to $1,018 per month. Some tenants live in rental units that are not protected by the rent increase guideline. These include units in newer buildings first occupied after 2005, units renting for $1,640 or more per month, government-owned units, and Manitoba Social Housing Rental Program, SHRP units. If the rent increase is within the guideline, there is no process for making an objection to the Residential Tenancies Branch. The Residential Tenancies Branch is a government body that provides information to both tenants and landlords about their rights and obligations. The Residential Tenancies Branch also investigates matters between tenants and landlords. It's important to know that your landlord may be able to legally raise your rent more than the set yearly guideline amount. They can do this by applying to the Residential Tenancies Branch and showing their costs have gone up by more than what the guideline amount would cover. The branch can either approve or not approve the increase. The landlord would have to apply to the branch at least 2.5 months before the increase happens. They must include a detailed listing of the increased costs they must pay to operate the building and the costs of repairs, replacements, or other upgrades they have already paid for. A landlord cannot apply for an increase above the guideline for future or planned expenses. For example, if the landlord is asking for an increase above the guideline because of the cost to replace all the building's windows, they must have already replaced and paid for the new windows when they apply for the increase. The Residential Tenancies Branch then sends a notice to the tenants, which tells them about their right to object to the rent increase. However, the increase may go ahead, even if you did not get the notice. Objections to the rent increase must be given to the Residential Tenancies Branch at least 60 days before the proposed rent increase is to go into effect. Reasons for objecting to the proposed increase include the landlord is not maintaining the unit or building, the landlord has reduced or withdrawn a service, the landlord is not meeting their obligations under the tenancy agreement, or the landlord's costs have not increased. When a landlord applies for a rent increase above the guideline, the branch sends a notice to tenants inviting them to come to the Residential Tenancies Branch during normal office hours to read the landlord's application and supporting material. Tenants must show identification to prove that they live at the residential complex before they are allowed to look at the file. Tenants can make their own written notes about the material, but the branch is not allowed to give out copies. In special circumstances, the branch may arrange for tenants to look at a file outside normal office hours. If the residential complex is outside Winnipeg, Brandon, or Thompson, the branch arranges for the tenants to look at a copy of the file in or near their community. The landlord has the right to see and respond in writing to any comments the tenants give to the branch. The branch will then review the comments made by the landlord and tenants, as well as rent roll information or rent history, services added or withdrawn during the rent comparison periods, any open repair files on the building, and the landlord's responses to repair requests. The branch does not consider comments about the effect of the increase on tenants' financial situations or well-being. The branch will usually only consider written comments and documents, and there is not usually an in-person hearing. Once the branch has reviewed everything, it will make an order setting the rent increase amount allowed. The order will include the branch's reasons. Sometimes the branch will make a conditional decision. For example, they may allow the rent increase, but only after certain repairs have been completed. Both the landlord and tenants get copies of the order, and the branch closes the file. The tenants are no longer allowed to read the landlord's application and supporting material, and the landlord is no longer allowed to read the tenant's objections and written comments. If the tenant or the landlord disagrees with the branch's order, they can appeal to the Residential Tenancies Commission within 14 days of receiving it. There would then be an in-person hearing with a panel. The Residential Tenancies Commission is the government body that deals with appeals from the Residential Tenancies branch. A government commissioner, a landlord representative, and a tenant representative would be on the panel. The landlord and tenant are notified in advance. After the hearing, the Residential Tenancies Commission decides, and that decision is final. A tenant whose rent is raised over the guideline amount during their lease also has the right to end their lease early. You may give notice that you are ending your lease early at any time from the date you received notice that the landlord applied or intends to apply for an above guideline rent increase to 14 days after you receive the branch's order or the Residential Tenancies Commission's decision. You must give your notice in the standard Notice of Termination by Tenant form with at least 2 rental payment periods notice. Here are some tips for objecting to a rent increase. Pay attention to your mail, especially if it has been 9 months or more since your last rent increase. There can be as little as 2 weeks for you to file an objection from the time you receive the notice of the proposed increase. It takes most people time to plan to do the things needed to make a written objection. Many tenants find it stressful and time-consuming to deal with these notices, but if you and other tenants do not respond, it is much more likely that the increase will go ahead at the full rate proposed by the landlord. The rent increase will be permanent, and there is no way to make an objection after the increase has been approved. It may be helpful to get together with other tenants in your building and share the workload of visiting the Residential Tenancies branch, reviewing the landlord's information and numbers, and making comments about whether they are accurate and whether the costs seem reasonable. Tenants should look closely at the costs that landlords have listed as capital expenses and operating expenses to make sure they are completely accurate. In the calculation for a rent increase, landlords can claim all of their operating expenses, such as property taxes, utilities, and maintenance, but only a percentage of their capital expenses, such as replacing all the appliances in the building. If they have not classified their expenses correctly, the rent increase could be lower than they requested. Landlords must fill in many details about the facilities and services they provide, and these can make an important difference in the application. Tenants should make sure these details are accurate because they have first-hand knowledge about the building that the Residential Tenancies branch does not have. Tenants should also look at costs for repairs that the landlord listed in the application and compare them to the going rate for repairs. If the costs are not reasonable, the landlord should not be able to pass along the full cost to tenants. For more information, visit the Community Legal Education Association's website at www.communitylegal.mb.ca.